In the United Kingdom, firearms are tightly controlled by law, though shooting organisations provide opposition to this legislation. These laws are much less restrictive in Northern Ireland than in the rest of the UK. In 2012, the British Shooting Sports Council believed that the law needed to be consolidated, but did not call for a review. The United Kingdom has one of the lowest rates of gun homicides in the world. There were 0.04 recorded intentional homicides committed with a firearm per 100,000 inhabitants in 2010. Gun homicides accounted for 2.4% of all homicides in the year 2009. With the exception of Northern Ireland, it has been public policy that police officers in the United Kingdom should not generally be armed with firearms. Shooting fatalities of members of the police are extremely rare. There were 3 in England and Wales in the 11-year period from 2000 January to 2010/11. About 7,000 police officers have received firearms training. Standard police firearms include semi-automatic carbines, and pistols, such as the Heckler & Koch G36, Heckler & Koch MP5 SF, and Glock 17. Shooting sports split into different categories in the UK between target shooting, clay pigeon shooting, pest control, and hunting. Sports, once a relatively elitist activity, have become far more popular in modern times amongst people from all walks of life. Many modern civilian rifle clubs trace their history to the volunteers of the middle 19th century, raised locally among the gentry to afford some readiness to counter the constant threat of invasion by Napoleon III. These volunteer organizations and military shooting clubs developed over time into civilian clubs as the volunteer organizations were incorporated into the Territorial Army. The rise in popularity in the civilian clubs started in the late 19th and early 20th centuries, especially Fulber rifle events sponsored by the Military and National Rifle Association of the United Kingdom to improve the general standard of marksmanship under the auspices of defence of the realm. Impact of firearm legislation. In 2012, the Home Office reported that, in 2010 November, firearms were involved in 11,227 recorded offences in England and Wales, the 7th consecutive annual fall. Firearms statistics in England and Wales include air guns and imitation guns, which make up a high proportion of these recorded offences. Fully automatic are prohibited weapons, and require explicit permission from central government to permit ownership. Generally, such permits are not available to private citizens. Semi-auto rifles over .22 and pistols are similarly prohibited, although there are exceptions for short-barreled breech-loading semi-auto and revolver pistols for use for the humane dispatch of animals. There are also very limited exceptions for pistols, both to preserve firearms of historic or technical interest and to enable use by elite sports teams. Semi-auto shotguns are legal. All other rifles and their ammunition are permitted with no limits as to magazine size. They may include target shooting, hunting, and historic and muzzle-loading weapons, as well as long-barreled breech-loading pistols with a specific overall length, but not for self-defense. However, if a homeowner is threatened, they may be used in self-defense. Shotgun possession and use is controlled, and even low-power air rifles and pistols, while permitted, are controlled to some extent. A firearms certificate issued by the police is required for all weapons and ammunition except air weapons of modest power for rifles, and 6 EFTA pound force for pistols. Shotguns with a capacity of 3 rounds or less are subject to less stringent licensing requirements than other firearms and require a shotgun certificate. Shotguns with higher capacity require a firearms certificate. Possession of a live firearms round can lead to severe penalties. Live firearms ammunition not including obsolete rounds or shotgun cartridges must be purchased and kept on a firearms certificate. Shotgun cartridges can be possessed by anybody over the age of 15, but no license is required to hold such ammunition so long as the cartridges contain 5 or more shot. But a license covering possession of a firearm capable of firing shotgun ammunition is required for purchase. These can however be gifted to someone between the age of 15 and 18. While Scotland has had its own parliament since the Scotland Act 1998, power to legislate on firearms was reserved to the Westminster Parliament, which led to tensions between the British and Scottish parliaments, with the Scottish government wanting to enact stricter laws. In Northern Ireland, possessing a firearm with a firearm certificate issued by the Police Service of Northern Ireland is legal. Firearms control laws in Northern Ireland are primarily regulated by the Firearms Order 2004, slightly different from the law in Great Britain. Gun licensing and legislation. The legislation is interpreted in different ways by different police authorities. For example, some authorities allow clubs to possess long-barreled pistols for members to use, and allow members who own them to allow other members to use them. Other authorities place the condition that only the owner may fire them. It is considered an offence for anyone else to even touch the firearm. This effectively requires members each to own their own pistol. In 2002 the Home Office issued Firearms Law Guidance to the Police, a 212-page long document. A revised version was published in October 2013. Classifications of firearms. Rifles. British law defines a rifle as a rifled firearm with a barrel longer than 30 cm, and a total length longer than 60 cm that does not fall under the classification of long-barreled revolver or pistol. Single shot, bolt action, martini action, lever action and revolver rifles and carbines are permitted, with certificate, in any caliber. Self-loading or pump-action rifles are only permitted in .22 rimfire caliber. Pistols. The 1997 law did not ban pistols as such and was drafted in terms of small firearms. British law defines a pistol as a firearm with a barrel shorter than 30 cm or a total length of less than 60 cm. Only muzzle-loading pistols including muzzle-loading revolvers are permitted. In practice all such firearms use black powder a Class 1 explosive as the propellant. Small quantities of muzzle-loading pistols and revolvers in various calibers, which comply with the regulations, are manufactured. All other pistols are prohibited on the UK mainland, with some exceptions such as pistols used for the humane dispatch of injured animals and some historical firearms. Specific models of blank-firing starting pistol that are readily convertible to fire live ammunition can also be banned. The Bruni Olympic .380 BBM blank-firing revolver was banned in 2010 on evidence that it was being illegally converted. Long-barreled revolvers and pistols. Long-barreled revolvers, and long-barreled pistols meeting specified criteria are not classified as small, and hence prohibited, firearms. It is legal, with a firearm certificate, to possess them. The barrel must be at least 30 cm long, and the firearm at least 60 cm long, which can be achieved by having a permanently attached extension to the grip or butt of the firearm. Long-barreled single-shot firearms of any caliber, and semi-automatic pistols of .22 rimfire calibers, are permitted with FAC. Target pistols. Aside from special temporary exemptions for major events such as the 2012 Olympics, pistol shooting for sporting purposes has been effectively banned since 1997. As a result, the GB Pistol Squad has to practice abroad. A few models of single-shot .22 caliber free pistol, as used in the 50 AM Olympic free pistol match, have been produced to meet the long-barreled pistol conditions. Some free pistols have removable stabilizer bars extending backwards to improve stability. The UK legal models have been made with non-removable stabilizers to extend the dimensions, instead of contrived and non-functional grip extensions. Examples are the single-shot Bedini K22 longarm and the Westlake Britarms long pistol, a permitted .22 LR 5-shot semi-automatic pistol. Shotguns, single-barreled, double-barreled shotguns, or those with a lever action or pump action, or semi-automatic and fixed magazine capacity of no more than 3 cartridges are permitted on a shotgun certificate. Shotguns with a detachable magazine or larger fixed magazine are permitted on a Section 1 firearms certificate. Certain types of shotgun ammunition, such as rifled slugs and larger shot sizes, can only be bought following the grant of an FAC. There is no limit on the amount of guns or ammunition that a SGC holder can acquire or possess at one time, although each shotgun is recorded on the certificate. Air guns. Air guns are firearms like any other according to the definition given in the Firearms Act 1968 at Section 57(1). However, they are exempt from the requirement that a firearm certificate or shotgun certificate need be obtained to possess or acquire them provided that they meet certain limits as to their power. Air pistols with a muzzle energy not exceeding 6 FTA pound-force and other air guns with a muzzle energy not exceeding 12 FTA pound-force do not require a certificate and may be acquired, purchased and possessed by anyone over the age of 18 and who is not a prohibited person as specified in Section 21 of the Act, which relates to persons previously convicted of crime. The UK Violent Crime Reduction Act 2006 controls online or mail-order sales of air guns by way of trade or business. Transactions must be finalised face-to-face, although the contract of sale may take place at a distance. The air gun may be sent by the seller to a registered firearms dealer from whom the gun may be collected by the purchaser. The same Act introduced the requirement that a person selling air guns or ammunition for air guns by way of trade or business be a registered firearms dealer. It is not an offence for a private individual to sell an air gun to another person as long as both parties are not legally barred from possessing air guns and the transaction does not constitute a business activity. It became a crime to fire an air weapon beyond the boundary of any premises without the occupier's permission, and increased the lower age limit for buying or possessing an air weapon to 18 years. From February 10, 2011, the Crime and Security Act 2010 made it an offence for a person in possession of an air weapon to fail to take reasonable precautions to prevent any person under the age of 18 from having the weapon with him. Any person who is in a building or is on land as a trespasser whilst having a firearm with him commits the offence of trespassing with a firearm. It is immaterial whether or not he has any ammunition with him at the time or whether he actually intends to use it at the place in which he was trespassing. Airsoft and plastic BB guns, two-tone airsoft or other soft air guns firing plastic BBs do not require any kind of license, and are not controlled by the state, or by local police forces, but cannot be sold to any person under the age of 18. If a person under the stated age wants to train with, use, or fire the gun, they must be accompanied by an adult. In the case of an imitation firearm, a person must have a valid reason for wanting to own one, even though the process is not nearly as strictly controlled as in the case of a firearm. To obtain an imitation-looking soft air or other plastic BB gun for skirmishing, you must be a regular airsoft skirmisher at an insured airsoft site and possess AB registered in the UK ARA database. Ammunition, explosive, incendiary, noxious and armor-piercing ammunition types are prohibited for civilians, although this ban created a problem for the authorities as expanding ammunition is needed for hunting and vermin control. Expanding ammunition is not only permitted but a legal requirement for deer stalking. Holders of FAC for the purpose of shooting or deer stalking are required to have authorization to acquire and possess expanding ammunition noted on it. The amount of ammunition allowed for purchase and possession is determined by conditions stated on an FAC. Prohibited firearms. The following are generally prohibited: fully automatic or burst-fire weapons, which may include some air guns. Firearms disguised as another item, rockets and mortars. Air guns chambered for self-contained gas cartridges. Any weapon of whatever description designed or adapted for the discharge of any noxious liquid, gas or other thing. This would generally include stun guns, or electric shock devices, and CS gas. Cattle prods would not generally be included, but it would depend on the type. Firearms which previously fell into a prohibited category, but have been converted to an otherwise permitted form. For example, a pistol which is adapted by permanently fitting a 60 cm long smoothbore barrel to it does not thereby become permitted. Firearm licensing. With a few specialized exceptions, all firearms in the United Kingdom must be licensed on either a 5-year firearm certificate or a shotgun certificate issued by the police for the area in which they normally reside. Each certificate can list multiple firearms, and the certificate remains valid until expiry even if all the listed firearms were subsequently banned. Shotguns are defined in UK law as smoothbore firearms with barrels not shorter than 24 inches and a bore not larger than 2 inches in diameter, no revolving cylinder, and either no magazine or a non-detachable magazine that is not capable of holding more than 2 cartridges, plus 1 in the chamber. Shotguns with higher capacity require a firearm certificate. Shotguns thus defined are subject to a less rigorous certification process than for the full FAC. An applicant is not required by law to make a good case for being granted a certificate, but the police may withhold a certificate if they consider that the applicant does not have satisfactory security in place, or granting it would constitute a danger to public safety or to the peace. A certificate holder may possess as many shotguns as can be securely stored. When applying for a firearm certificate, justification must be provided to the police for each firearm, and they are individually listed on the certificate by type, caliber, and serial number. A shotgun certificate similarly lists type, caliber and serial number, but permits possession of as many shotguns as can be safely accommodated. To gain permission for a new firearm, a variation must be sought, for a fee, unless the variation is made at the time of renewal, or unless it constitutes a one-for-one replacement of an existing firearm that will be disposed of. The certificate also sets out, by caliber, the maximum quantities of ammunition someone may buy or possess at any one time, and is used to record ammunition purchases. To obtain a firearm certificate, the police must be satisfied that a person has good reason to own each firearm, and that they can be trusted with it without danger to the public safety or to the peace. Under Home Office guidelines, firearms certificates are only issued if a person has legitimate sporting, collecting, or work-related reasons for ownership. Since 1968, self-defense has not been considered a valid reason to own a firearm. The current licensing procedure involves positive verification of identity, 2 referees of verifiable good character who have known the applicant for at least 2 years, approval of the application by the applicant's own family doctor, an inspection of the premises and cabinet where firearms will be kept, and a face-to-face interview by a firearms inquiry officer, also known as a firearms liaison officer. A thorough background check of the applicant is then made by special branch on behalf of the Firearms Licensing Department. Only when all these stages have been satisfactorily completed will a license be issued, which must be renewed every 5 years. Any person who has been sentenced to between 3 months and 3 years in prison is automatically prohibited from possessing firearms and ammunition for 5 years from release. A person who has been sentenced to more than 3 years is prohibited for life. Application may be made to a court to reverse these prohibitions, and this is likely to be successful in relation to convictions for crimes which do not relate to a person's fitness to possess firearms. Similarly, persons applying for licenses with recent, serious mental health issues will also be refused a certificate. Any person holding a firearm or shotgun certificate must comply with strict conditions regarding such things as safe storage. These storage arrangements are checked by the police before a license is first granted, and on every renewal of the license. In the case of a firearm certificate, the issuing police force may impose additional conditions over and above the statutory ones. However, any condition appended to a certificate must be reasonable and must not be of such a restrictive nature as would amount to a constructive refusal to grant the certificate by making use so unlikely as to be practically impossible. Failure to comply with any of these conditions can result in criminal prosecution, resulting in a prison sentence of up to 6 months. Revocation of the certificate is also possible, depending upon the nature of the breach. A visitor's permit is available for possession of firearms without certificate by visitors to Britain. The penalty for possession of a prohibited firearm without a certificate is a maximum of 10 years in prison and an unlimited fine. The penalty for Section 5 categories of firearm is subject to a mandatory minimum of 5 years. The Violent Crime Reduction Act 2006 increased restrictions on the use, possession, sale and manufacture of both airguns and imitation firearms. Northern Ireland, more than 100,000 people in Northern Ireland own firearms, having 380,000 among them. Gun control laws in Northern Ireland are less restrictive than gun laws in the rest of the UK, due to the Good Friday Agreement, allowing Northern Ireland to govern itself and pass less restrictive laws. Gun laws in Northern Ireland are primarily affected by the Firearms Order 2004. Under the new law, First-time buyers will be required to demonstrate they can be trusted with the firearm. It will be up to firearms dealers selling the products to tell new buyers, and those upgrading their firearms, about the safety procedures. Firearm possessors in Northern Ireland must not transport their firearms to Great Britain. All gun owners in Northern Ireland are required to apply for a firearms certificate to possess firearms. Permits are normally issued to anyone who has good reason to possess firearms, such as target shooting, hunting, and personal protection. Northern Ireland is the only part of the United Kingdom where personal protection is accepted as a legitimate reason to obtain and own a firearm, and is the only part of the United Kingdom where handguns are permitted. Semi-automatic rifles are only permitted when chambered in .22 caliber. Handguns and shotguns are permitted in any caliber. There is no limit on magazine capacity for rifles and handguns, and the magazine limit for shotguns is 2 rounds. Also, carrying a firearm in plain view in a public place is allowed without a permit. Open carry of handguns is not common. However, in the countryside, people will often open carry loaded rifles and shotguns. A firearm certificate for a personal protection weapon will only be authorised where the Police Service of Northern Ireland deems there is a verifiable specific risk unregistered trademark to the life of an individual, and that the possession of a firearm is a reasonable, proportionate and necessary measure to protect their life. Permits for personal protection also allow the holder to carry their firearms concealed. They may also allow the holder to possess fully automatic weapons and centre-fire semi-automatics in some instances. Scotland. Gun laws in Scotland differ in some details from those in the rest of the UK. However, in terms of licensing they are, currently, identical to the rest of Great Britain. A firearms certificate is required to purchase firearms, and a separate shotgun certificate is required for shotguns. The guiding laws for firearms in Scotland are the Firearms Rules 1989 and the Firearms Act. All handguns, semi-automatic and pump-action non-rimfire rifles are prohibited. A few pistols are licensed on a firearm certificate for exactly the same reasons as the rest of Great Britain. There are only 566 licensed handgun owners in Scotland. In December 2012, the Scottish Government launched a consultation on proposals for licensing air weapons in Scotland. The Justice Secretary's foreword in the consultation paper stated that the government does not intend to ban air weapons outright, but does not think that it is appropriate in our modern Scotland that there can be up to 500,000 unregistered, uncontrolled and often forgotten firearms in circulation. It stated an aim to ensure that only those people with a legitimate reason for owning and using an air gun should have access to them in the future, and that they are properly licensed and accounted for. Indiana, 2011/12. There were 195 offences involving air weapons in Scotland, compared to 3,554 in England and Wales. The consultation closed in March 2013 with 1,101 responses, 87% of which were opposed to the principle of licensing air weapons. In July 2013, Shooting UK reported that a petition against the introduction of air weapon licensing in Scotland had so far gained 14,193 signatures. Petition founder Dave Ewing, who was due to appear before the Scottish Parliament's Public Petitions Committee in September, was reported as being pleased with the response to date, but that it is very important for people to continue signing and showing support, as the shooting community must pull together to defend our rights. Every single law-abiding person that is deterred from shooting due to overly restrictive laws or unfair financial hurdles weakens the shooting community. BASC and the Scottish Gamekeepers Association is also supporting the petition, with the SGA's George MacDonald saying, "Responsible people object to having legislation forced upon them where there is no demonstrable need." The statistics for misuse of an airgun are very low. Gun control legislation in the United Kingdom. Many laws and amendments governing possession and use of firearms have been enacted over the years. See Firearms Act United Kingdom for a more complete list. There were growing concerns in the 16th century over the use of guns and crossbows. 4 acts were imposed to restrict their use. The Bill of Rights restated the ancient rights of the people to have arms by reinstating the right of Protestants to have arms after they had been illegally disarmed by James II. The bill follows closely the Declaration of Rights made in Parliament in February 1689. Whereas the late King James II, by the assistance of divers evil counsellors, judges, and ministers, employed by him, did endeavour to subvert and extirpate the Protestant religion, and the laws and liberties of this kingdom, by assuming and exercising a power of dispensing with and suspending of laws, and the execution of laws, without consent of Parliament, by causing several good subjects, being Protestants, to be disarmed, at the same time when Papists were both armed and employed contrary to law. Which are utterly and directly contrary to the known laws and statutes and freedom of this realm, the said Lords Spiritual and Temporal and Commons, pursuant to their respective letters and elections, being now assembled in a full and free representative of this nation, taking into their most serious consideration the best means for attaining the ends aforesaid, do in the first place, for the vindicating and asserting their ancient rights and liberties, declare, that the subjects which are Protestants may have arms for their defence, suitable to their condition, and as allowed by law. The rights of English subjects, and, after 1707, British subjects, to possess arms was recognised under English common law. Sir William Blackstone's Commentaries on the Laws of England, were highly influential and were used as a reference and textbook for English common law. In his commentaries, Blackstone described the right to arms. The fifth and last auxiliary right of the subject, that I shall at present mention, is that of having arms for their defence, suitable to their condition and degree, and such as are allowed by law. Which is also declared by the same statute IW. And MST 2. C2 and is indeed a public allowance, under due restrictions, of the natural right of resistance and self-preservation, when the sanctions of society and laws are found insufficient to restrain the violence of oppression. Formerly, this same British common law applied to the UK and Australia, and until 1791 to the colonies in North America that became the United States. The no longer applicable right to keep and bear arms had originated in England during the reign of Henry II with the 1181 Assize of Arms, and developed as part of common law. After the Jacobite rebellions of 1715 and 1745, harsh laws providing, amongst other things, for disarming the Highlands of Scotland, were enacted by the Parliament of Great Britain, the Disarming Acts of 1716 and 1725, and the Act of Prescription 1746. The first British firearm controls were introduced as part of the Vagrancy Act 1824, which was set up in a reaction against the large number of people roaming the country with weapons brought back from the Napoleonic Wars. The act allowed the police to arrest any person with any gun, pistol, hanger, dagger, cutlass, bludgeon or other offensive weapon, with intent to commit a felonious act. This was followed by the Night Poaching Act 1828 and Night Poaching Act 1844, the Game Act 1831, and the Poaching Prevention Act 1862, which made it an offence to illegally shoot game using a firearm. The Gun License Act 1870 was created to raise revenue. It required a person to obtain a license to carry a gun outside his own property for any reason. A license was not required to buy a gun. The licenses cost 10 shillings, lasted 1 year, and could be bought over the counter at post offices. Pistols Act 1903. The Pistols Act 1903 was the first to place restrictions on the sale of firearms. Titled an Act to regulate the sale and use of pistols or other firearms, it was a short act of just 9 sections, and applied solely to pistols. It defined a pistol as a firearm whose barrel did not exceed 9 in length and made it illegal to sell or rent a pistol to anyone unless they could produce a current gun license or game license, were exempt from the Gun License Act, could prove that they planned to use the pistol on their own property, or had a statement signed by a police officer of inspector's rank or above or a justice of the peace to the effect that they were about to go abroad for 6 months or more. The act was more or less ineffective, as anyone wishing to buy a pistol commercially merely had to purchase a license on demand over the counter from a post office before doing so. In addition, it did not regulate private sales of such firearms. the legislators laid some emphasis on the dangers of pistols in the hands of children and drunkards and made specific provisions regarding sales to these two groups. Persons under 18 could be fined 40 shillings if they bought, hired, or carried a pistol, while anyone who sold a pistol to such a person could be fined £5. Anyone who sold a pistol to someone who was intoxicated or of unsound mind was liable to a fine of £25 or 3 months' imprisonment with hard labour. However, it was not an offence under the Act to give or lend a pistol to anyone belonging to these two groups. 1920 Firearms Act. The Firearms Act of 1920 was partly spurred by fears of a possible surge in crime from the large number of firearms available following World War I and in part due to fears of working-class unrest in this period. An act to amend the law relating to firearms and other weapons and ammunition, its main stated aim was to enable the government to control the overseas arms trade and so fulfill their commitment to the 1919 Paris Arms Convention. Shootings of police by militant groups in Ireland may also have been a factor as Britain and Ireland were at that time still in union with each other and the Act applied thereto. It required anyone wanting to purchase or possess a firearm or ammunition to obtain a firearm certificate. The certificate, which lasted for 3 years, specified not only the firearm but the amount of ammunition the holder could buy or possess. Local chief constables decided who could obtain a certificate, and had the power to exclude anyone of intemperate habits, or unsound mind, or anyone considered for any reason unfitted to be trusted with firearms. Applicants for certificates also had to convince the police that they had a good reason for needing a certificate. The law did not affect smoothbore guns, which were available for purchase without any form of paperwork. The penalty for violating the Act was a fine of up to £50 or imprisonment with or without hard labour for a term not exceeding 3 months, or both. The right of individuals to bear arms had previously been, in the words of the 1689 Bill of Rights, as allowed by law. The 1920 Act made this right conditional upon the Home Secretary and the police. A series of classified Home Office directives defined for the benefit of chief constables what constituted good reason to grant a certificate. These originally included self-defense. As the 1920 Act did not prevent criminals from obtaining firearms illegally, in 1933 the Firearms and Imitation Firearms Bill was submitted to Parliament. It increased the punishment for the use of a gun in the commission of a crime and made it an offence punishable by up to 14 years imprisonment for anyone to attempt to make use of any firearm or imitation firearm to resist arrest. Possession of a real or imitation firearm was also made an offence unless the possessor could show he had it for a lawful object. 1937 Firearms Act. The 1937 Firearms Act incorporated various modifications to the 1920 Act based on the recommendations of a 1934 committee chaired by Sir Archibald Bodkin. The resulting legislation raised the minimum age for buying a firearm or airgun from 14 to 17, extended controls to shotguns and other smoothbore weapons with barrels shorter than 20 in, transferred certificates for machine guns to military oversight, regulated gun dealers, and granted chief constables the power to add conditions to individual firearms certificates. The same year, the Home Secretary ruled that self-defense was no longer a suitable reason for applying for a firearm certificate, and directed police to refuse such applications on the grounds that firearms cannot be regarded as a suitable means of protection and may be a source of danger. 1968 Firearms Act. The Firearms Act 1968 brought together all existing firearms legislation in a single statute. Disregarding minor changes, it formed the legal basis for British firearms control policy until the Firearms Act 1988 was put through Parliament in the aftermath of the 1987 Hungerford massacre. For the first time, it introduced controls for long-barreled shotguns, in the form of shotgun certificates that, like firearm certificates, were issued by an area's chief constable in England, Scotland, and Wales. While applicants for firearms certificates had to show a good reason for possessing the firearm or ammunition, this did not apply to shotgun certificates. Firearms had to be locked up, and ammunition stored and locked in a different cabinet. This was introduced after the 1973 Green Paper, which advocated more controls on firearms. The Act also prohibited the possession of firearms or ammunition by criminals who had been sentenced to imprisonment. Those sentenced to 3 months to 3 years imprisonment were banned from possessing firearms or ammunition for 5 years, while those sentenced to longer terms were banned for life. However, an application could be made to have the prohibition removed. The act was accompanied by an amnesty. Many older weapons were handed in to the police. It has remained a feature of British policing that from time to time a brief firearms amnesty is declared. The Firearms Act 1988, in the aftermath of the Hungerford Massacre, Parliament passed the Firearms Act 1988. This confined semi-automatic and pump-action centre-fire rifles, military weapons firing explosive ammunition, short shotguns that had magazines, and both elevated pump-action and self-loading rifles to the prohibited category. Registration and secure storage of shotguns held on shotgun certificates became required, and shotguns with more than a 2+1 capacity came to need a firearm certificate. The law also introduced new restrictions on shotguns. Rifles in .22 rimfire and semi-automatic pistols were unaffected. 1997 Firearms Act. Following the Dunblane Massacre, the government passed the Firearms Act 1997 and the Firearms Act 1997, banning private possession of handguns almost completely. Exceptions to the ban include muzzle-loading black powder guns, pistols produced before 1917, pistols of historical interest, starting pistols, pistols that are of particular aesthetic interest, and shot pistols for pest control. Under certain circumstances, individuals may be issued a PPW license. Even the UK's Olympic shooters fall under this ban. Shooters can only train in Northern Ireland, the Channel Islands, the Isle of Man, or abroad. 162,000 pistols and 700 tons of ammunition and related equipment were handed in by an estimated 57,000 people, 0.1% of the population, or 1 in every 960 persons. At the time, the renewal cycle for FACs was 5 years, meaning that it would take 6 years for the full reduction of valid certificates for both large caliber and .22 handguns bans. On December 31, 1996, prior to the large caliber handgun ban, there were 133,600 FACs on issue in England and Wales. By December 31, 1997 it had fallen to 131,900. The following year, after the .22 handgun ban, the number stood at 131,900. On December 31, 2001, 5 years after the large caliber ban, the number had fallen to 119,600 and 117,700 the following year. This represents a net drop of 24,200 certificates. Comparable figures for Scotland show a net drop of 5,841 from 32,053 to 26,212 certificates, making a gigabyte total net drop of 30,041. However, while the number of certificates in England and Wales rose each year after 2002 to stand at 126,400 at March 31, 2005, those in Scotland remained relatively static, standing at 26,538 at December 31, 2005. Violent Crime Reduction Act 2006, this act is focused around various vice-type misdemeanors, including dealing with weapons. From April 6, 2007 the sale and transfer of air weapons by mail order became an offence, as well as the sale of primers, and realistic imitation firearms. The only exceptions are for the purposes of military and historical reenactment, media and theatre production, paintballing and airsoft as a sport. This has affected airsoft in the UK by restricting the sale, import and purchase of airsoft replicas to individuals entitled to the skirmisher-specific defence, that is members of an organised airsoft skirmish site holding permitted activities with third-party liability insurance cover. The 2012 Olympics. Following the awarding of the 2012 Olympic Games to London, the government announced that special dispensation would be granted to allow the various shooting events to be held, as had been the case previously for the 2002 Commonwealth Games. Further dispensations allowed foreign participants in shooting events to train in the UK, even though it remained illegal for native pistol shooters to train in England, Scotland or Wales. Controversially, shooting events for the games were held at a temporary facilities at the Royal Artillery Barracks in Woolwich, with the cost of £42 million including their subsequent demolition. Shooting sports bodies and some politicians argued that the money would have been better spent on a lasting legacy that would be gained by refurbishing and upgrading permanent facilities at the National Shooting Centre at Paisley, which would have cost a maximum of £30 million. Attempt to license air guns in Scotland. In 2006, Glasgow politician Tommy Sheridan of the political party Solidarity launched a consultation to restrict possession of air guns, highlighting recent cases including the death of toddler Andrew Morton, but the Scottish Parliament did not have the power to ban air guns at the time, so any measures would have needed to be formally approved by Westminster. Around this time, the media gave some exposure to growing public desire to have air guns banned or regulated, particularly from the parents of a child that died after being struck in the head by a pellet in Easterhouse, one of Glasgow's many deprived areas. The child was said to have had a skull only 2 mm thick at the point of impact. MSPs such as Kenny McCaskill have claimed Scotland has a problem with air gun violence. However, official figures show that out of the estimated 500,000 airguns in Scotland there were only 195 offences, a ratio of less than 0.04%. Not all of these offences have been linked to violence, with many being minor. The Commission on Scottish Devolution, when implemented, gave the Scottish Parliament powers to regulate air guns. On December 14, 2012, a consultation was launched to investigate how a new licensing programme for air guns could work. Critics of the measure claimed this is unnecessary, as offences involving air guns have already decreased by 71% in the last 5 years. Firearms crime. A Home Office study published in 2007 reported that gun crime in England and Wales remained a relatively rare event. Firearms were used in 21,521 recorded crimes. It said that injury caused during a firearm offence was rare, with fewer than 3% of offences resulting in a serious or fatal injury. For 2011/12, police in England and Wales recorded 541 offences as homicide, of which 42 involved the use of firearms and a rate of 0.1 illegal gun deaths per 100,000 of population. The number of homicides per year committed with firearms in England and Wales remained between 39 and 81 in the 10 years to 2011/12, with an average of 56 per year. During the same time period, there were 3 fatal shootings of police officers in England and Wales, and 154 non-fatal shootings, an average of 15.4 per year. The overall homicide rates per 100,000 reported by the United Nations for 1999 were 4.55 for the US and 1.45 in England and Wales. The homicide rate in England and Wales at the end of the 1990s was below the EU average, but the rates in Northern Ireland and Scotland were above the EU average. While the number of crimes involving firearms in England and Wales increased from 13,874 in 1998/99 to 24,070 in 2002 March, they remained relatively static at 24,094 in 2003 April, and fell to 21,521 in 2005 June. The latter includes 3,275 crimes involving imitation firearms and 10,437 involving air weapons, compared to 566 and 8,665 respectively in 1998/99. The overall total declined progressively to 9,555 in 2011 December, with included 1,377 imitation and 3,554 air weapon offences. 201/12 saw yet a further fall to a total of 8,135, which included 1,225 imitation and 2,977 air weapon offences. Only those firearms positively identified as being imitations or air weapons are classed as such, so the actual numbers are likely to be significantly higher. Since 1998, the number of people injured by firearms in England and Wales increased by 110%, from 2,378 in 1998/99 to 5,001 in 2005 June. Most of the rise in injuries were in the category slight injuries from the non-air weapons. Slight in this context means an injury that was not classified as serious. Indiana, 2005/06, 87% of such injuries were defined as slight, which includes the use of firearms as a threat only. By 2011/12 the total number of injuries had fallen to 1,668, of which 1,434 were slight. In 2007, the British government was accused by Shadow Home Secretary David Davis of making inaccurate and misleading statements claiming that gun crime was falling, after official figures showed that gun-related killings and injuries recorded by police had risen more than fourfold since 1998, mainly due to a rise in non-fatal injuries. In 2007, Justice Minister Jacques Straw told the BBC, "We are concerned that within the overall record, which is a good one, of crime going down in the last 10 to 11 years, the number of gun-related incidents has gone up. But it has now started to fall." In 2008 The Independent reported that there were 42 gun-related deaths in Great Britain, a 20-year low. However, in late 2009 The Telegraph reported that gun crime had doubled in the last 10 years, with an increase in both firearms offences and deaths. A government spokesman said this increase was a result of a change in reporting practices in 2001 and that gun crime had actually fallen since 2005. Chris Grayling, the Shadow Home Secretary, attributed the rise to ineffective policing and an out-of-control gang culture. In the year April 2012 to March 2013 there were 11,227 recorded offences involving firearms, broken down as follows. By weapon type, long-barreled shotgun equals 288, sawn-off shotgun equals 165, handgun equals 2,256, rifle equals 43, imitation firearm equals 1,225, unidentified firearm equals 725, other firearm equals 456, air weapons equals 2,977, only those items proven to be imitations, or air weapons are classed as such, otherwise they are placed by default in the main live categories, for example an imitation pistol not proven to be such would be counted as a live handgun. Other firearm includes CS gas, pepper spray, and stun guns. By crime type, violence against the person. Homicide equals 30, attempted murder GBH with intent equals 503, other equals 1,484, robbery equals 2,206. Burglary equals 102, criminal damage equals 2426, other equals 1384. Spree killings and mass shootings. Britain has had very few spree killings or mass shootings in modern times. During the latter half of the 20th century there were only 2 incidents in which people holding licensed firearms went on shooting sprees and killed on a large scale, the Hungerford Massacre of 1987 and the Dunblane School Massacre of 1996. Each led to strong public and political demands to restrict firearm use, and tightening of laws. The result has been among the strictest firearms laws in the world. After Hungerford, the Firearms Act 1988 criminalized most semi-automatic long-barreled weapons. It was generally supported by the Labour opposition although some Labour backbenchers thought it inadequate. After the second incident, the Firearms Act 1997 criminalized private possession of most handguns having a caliber over .22. The Snowdrop campaign continued to press for a wider ban, and in 1997 the incoming Labour government introduced the Firearms Act, which extended this to most handguns with a caliber of .22, Hungerford Massacre. In 1987, 27-year-old Michael Ryan, armed with 2 semi-automatic rifles, and a Beretta 92 pistol, dressed in combat fatigues and proceeded around the town of Hungerford killing 16 people, wounding 15 and shooting himself, in what became known as the Hungerford Massacre. Ryan's collection of weapons had been legally licensed, according to the Hungerford Report. Dunblane Massacre. On March 13, 1996, Thomas Hamilton, aged 43, a former Scout leader who had been ousted by the Scout Association in 1974, shot dead 16 young children and their teacher, Gwyneth Mayer, in Dunblane Primary School's gymnasium with 2 Browning high-power 9mm pistols and 2 S&W .357 Magnum revolvers. He then shot himself. The 4 handguns used in the attack were legally owned. There is a memorial to the 17 victims in the local cemetery and a cenotaph in the cathedral. The funds raised in the aftermath of the tragedy have been used to build a new community center for the town. Personnel of the police firearms licensing office were unaware of Hamilton's expulsion by the Scout Association, nor were they aware of allegations made against him regarding unsavory behavior on a number of boys' summer camps he had organized, allegations that would have exposed his poor character. The tragedy led to improvements in interdepartmental sharing of police intelligence and deeper background checks of firearm certificate applicants. After the incident, legislation was introduced in 1997 to prohibit, with some extremely specialized exemptions, small firearms with a barrel length of less than 30 cm or an overall length of less than 60 cm. There was a marked increase in overall firearms homicides in the first few years following this legislation, but this was followed by a return to the situation before the ban. The actual number of fatal firearms injuries in England and Wales were 1998 99 equals 49, 1999/00 equals 62, 2000/01 equals 72, 2001/02 equals 96, 2002/03 equals 80, 2003/04 equals 68, 2004/05 equals 76, 2005/06 equals 49, 2006/07 equals 56, 2007/08 equals 53. 2008/09 equals 39 and 2009 tenths equals 39 and 2010 elevenths equals 58 and 2011 twelfths equals 42 and 2012 thirteenths equals 30. Cumbria shootings. On June 2, 2010, Derek Bird, a 52-year-old taxi driver, shot and killed 12 people and injured 11 others while driving through Cumbria. He then shot himself. Bird was a licensed firearms holder. His weapons were a 12-gauge double-barreled shotgun and CZ452-2 EZKM.22 caliber bolt-action rifle. Pro-gun organizations, BASC, the British Association for Shooting and Conservation is a non-profit making industrial and provident society, whose mission is to promote and protect sporting shooting and the well-being of the countryside throughout the United Kingdom and overseas. With around 130,000 members and 105 staff, BASC is the largest and best-resourced country sports organisation in the UK. Its magazine Shooting and Conservation has the largest circulation of any shooting magazine in Britain. Sporting shooting includes wildfowling, game, and rough shooting, deer stalking, target shooting and air gunning, pigeon shooting and pest control, gun dogs and promoting practical habitat conservation. BASC is also involved in the political representation of shooting Euro training and the setting of standards in shooting sports, and the association undertakes research in its area of interest. In 2006 the BASC commissioned an independent report into shooting. Public and corporate economic consultants concluded that British shooters spend an average £2 billion on goods and services annually, generating a £1.6 billion boost to the economy, and creates employment for 70,000 people. The same report states that shooting plays a major role in conservation. Countryside Alliance. The Countryside Alliance was created in 1997 as a response to the newly elected Labour government Euro unregistered trademark's pledge to ban hunting with dogs. An amalgamation of 3 organisations, the Countryside Business Group, the British Field Sports Society and the Countryside Movement, the Countryside Alliance has in its short life become a major British campaigning organisation on rural issues. With over 100,000 members, the Countryside Alliance defends and promotes country sports and rural life at Parliament, in the media and on the ground. Firearms UK. Firearms UK is a campaigning organisation based in the UK to promote and defend firearms ownership and the shooting sports. Main objectives of the organisation include to encourage unity and promote positive action within the UK shooting community to help protect against further restrictions placed against law-abiding firearms owners. NRA, The National Rifle Association of the United Kingdom was founded in 1859, and provides target and firearms training to help in the defence of the realm. See also, police use of firearms in the United Kingdom, police, armed response vehicle, lobbying in the United Kingdom, National Rifle Association of the United Kingdom, Firearms Inquiries Officer, Gun Politics, Gun Safe, British Association for Shooting and Conservation. Notes. References: Greenwood, Colin. Firearms Control, A Study of Armed Crime and Firearms Control in England and Wales. Routledge. ISBN A0-7100-7435-2. Malcolm, Joyce Lee. Guns and Violence, The English Experience. Harvard University Press. ISBN A0-674-01608-4. Waldron, Michael J. Armed Police, The Police Use of Firearms Since 1945. England, Sutton. ISBN A0-7509-4637-7. Utterly, Sandra. Dunblane Unburied. Book Publishing World. ISBN A19005553056. Legislation, relevant acts of Parliament. Information in the following references is released under Crown copyright by the Office of Public Sector Information. This allows reproduction free of charge in any format or medium provided it is reproduced accurately and not used in a misleading context. Firearms Act 1988, Statutory Instrument 1989 No. 853, the Firearms Act 1988 Order 1989, Statutory Instrument 1989 No. 854, the Firearms Rules 1989, Statutory Instrument 1989 No. 889, the Firearms Rules 1989, Firearms Act 1992. Statutory Instrument 1992 No. 2823, the Firearms Act Regulations 1992, Firearms Act 1994, Statutory Instrument 1994 No. 2615, the Firearms Order 1994, Firearms Act 1997, Firearms Act 1997, Statutory Instrument 2002 No. 127, the Firearms Act 1988 Order 2002, Firearms Order 2004 No. 7, Draft Statutory Instrument 2005 No. The Firearms Order 2005, 2008 European Directive, text of 2008 EC, external links, British Association for Shooting and Conservation, Campaign for Armed Self-Defence, Firearms UK, Gun Control Network, London Metropolitan Police Firearms Inquiry Team, Practical Shotgun Association, Responsibly Armed, Gun Control's Twisted Outcome.